Welcome everyone to our Name, Image, and Likeness series, part 2. We started last week with Mr. Luke Fedlam. He gave us an introduction to name, image, and likeness and some of the terms that we needed to be aware of and know as student athletes, as parents, as coaches, as administrators. Julie's going to take on a much different perspective, but they go hand in hand. So it's important that you understand the organization that Julie's going to be speaking of specifically and how they are doing work around name, image, and likeness. So without further ado, I'm going to go ahead and turn the floor over to Miss Julie Sommer. Thank you so much for being with us.
Thank you. It's great to be with everybody here this evening. Hope you can hear me all right. My name is Julie Sommer, as you saw in the bio there, as Dr. Goodlow mentioned. I am an attorney. I'm located in Seattle, Washington. And in addition to practicing law, I also do a good bit of volunteer work with an organization called the Drake Group. And we are a national think tank, a nonprofit, and basically our goals are to analyze college athletics policy, and we advocate on behalf of academic rights and academic standards for college athletes, and as well as everything that might fall under the athlete rights umbrella really are things that we review, that we work on in our working group, which I'm also a member of, and we meet weekly. But also there are many rights, as you know. The big one that we've been talking about for the last 2 years at least is name, image, likeness. So we have reviewed, and I have also closely tracked that with myself, tracking all of the various state legislatures that have been taking action since September 2019, when it started off with California. So we do a lot of work in the college athletic realm. That's really where our main focus is. It's not really doesn't go beyond that into high school, but naturally we'll talk about issues related to high school and high school athletic associations as well. And I'll discuss that a little bit as well tonight. I'll try and keep track of the chat room here to have questions. Feel free to let me know, Lizette, if something's popping up that I'm not seeing there, if I get too carried away here. So I don't want to, as you mentioned, Attorney Luke Fedlam was here last week, and I don't want to duplicate much of what he said, of course, but since so much his focus has been on name, image, and likeness, as well as other athlete compensation issues addressed by the Supreme Court this year, and that's what we've been spending a lot of time on currently with the Drake Group, in addition to academic standards and the other areas. There's a lot to cover. We could talk for a long time here. So I wanted to, whoops, hang on a second. So in terms of Luke, he addressed the state name, image, and likeness, also known as NIL laws. He discussed the Alston Supreme Court case, which was not an NIL case, but closely related because it addressed limits on the educationally related benefits for college athletes, as well as the antitrust concerns, which have been discussed a lot in intercollegiate athletics right now. He discussed a little bit about the states and the NCAA policy change, which of course happened at the same time that Florida and several other states went into effect this past July 1st. So what I'd like to do, since a lot of you are located in Texas, go into a little more detail on the Texas law, which is currently in effect, and other emergent NIL issues and related athlete compensation issues, because that is the topic of the day. So it's one thing it's important to remember is that institutions in states with state laws, those institutions, those schools are required to follow their state laws. And many of those state laws have a lot of several basic commonalities. Essentially, at right now, because we don't have a federal policy yet, every school has its own policy. Maybe that was sort of the holdback, restrained approach by the NCAA that went into effect in July. And we know that the NIL current bylaws now allow college athletes to profit off of their NIL, their name, image, likeness, but really with the current policy, which is slim in guidance right now, the devil's really in the details, and it's not so much what's in the current bylaws, but really what's not in the NCAA policy. In addition to what the NCAA is not doing in terms of enforcement and for any type of agreements that college athletes are currently engaging in. So I think Luke touched on the speed of how we got here. We went from one NIL state bill at the end of 2019, and less than 2 years later, we are 28 states now with some type of enacted NIL legislation. So the state bills accelerated very quickly. The only pause really in 2020 was because a lot of legislatures ended up adjourning early because of the pandemic. So it probably would have happened even more quickly, but for that. So again, many of you are located in Texas. You know likely that that Texas has a state NIL law. I'm a former swimmer at the University of Texas, so I have an interest in what's going on in Texas as well. 21 other states with legislation right now, and 7 other states also in effect with later effective dates. I know someone mentioned here the NLRB in the chat, and I'm definitely going to be addressing that. That was a ruling that was issued today, or an announcement issued today. Just to touch upon Texas a little bit, Texas definitely has some unique provisions in their law. Several are common with other state laws. The interesting thing about state legislatures and state laws is that some can be well written, and some aren't so well written. Some are very slim on their guidance. Some don't provide well-defined terms. Oftentimes a law will begin when you read the law, when you read the statute, it will begin by defining the terms that will be used throughout the provisions in the law, which is very helpful. And it might seem like a basic thing, but it's not always the case that is done. Texas does do that. And what's notable about Texas, and actually helpful, is that it defines what an institutional contract is and what a team contract is. Believe it or not, most of the state laws don't actually define those terms, and it can be quite ambiguous and a little bit confusing when you start talking about conflicts, team contracts, and what are they really referring to. So the Texas law defines the institutional contract as a contract between the institution and a third party, including sponsorship agreement governing the use of the institution's trademarks. So that's the school's contract. The team contract means a contract between a college athlete and an institution. So that could include the rules, expectations of the school's athletic department, or even the coach, that require a college athlete's compliance as a condition to being a member of their athletic program. So that's helpful about Texas. This can also, the Texas law provides for, as many other do, professional representation, including representation by a lawyer. They say licensed to practice in this state, in Texas, for contracts or other legal matters, if they are in fact going to be assisting with your contracts. So disclosure, it's another important topic that many of the state laws address. Again, not all of them, but there's going to be, in Texas, there is a disclosure requirement. So if a college athlete seeks to engage in an agreement with a third party, the Texas law states that they shall, meaning they will, before entering into the contract, disclose to the school in any way the school determines the proposed contract. So before they enter into it, they shall disclose that. And if there's a provision that conflicts with the school, with the team contract, with the institutional contract, then they have to disclose that. They're going to know that. So you should know that also what the honor code is at the school. State law also addresses what's called objectionable categories, which I'll mention in a second as we wrap up what the Texas law requires. What's prohibited in the Texas law is that compensation for the college athletes NIL is not in exchange for actual athletic performance or attendance at the institution. That's an issue that's being discussed a lot today. And as someone already asked what the NLRB in the chat there, that stands for National Labor Relations Board. And that's what they're getting at with their announcement today in their memorandum, the General Counsel. And I'll get into a little more detail on that. But basically what this means is what's prohibited under the current Texas state law, which is at conflict with that memorandum, is that it can't be in exchange for athletic performance, i.e. no pay for play. They basically state that they are not an employee for the purpose of competing in college athletics. The Texas state law also states that a college athlete cannot use their NIL rights in exchange for any property owned by the institution, or using any intellectual property owned by the institution. So trademarks, the Texas Longhorn, perhaps definitely the logo. Will that also include the color burnt orange? What's interesting about this is that some schools are entering into group licensing and co-licensing agreements with their schools. So essentially the schools are choosing to grant to all their athletes, and the ones I've seen so far, the right to use the institution's trademarks, their marks, UT being one of them. And I think that we'll likely see more of that. That Texas included in their law the objectionable product category. So you are not able to use your NIL rights in exchange for endorsement of alcohol, tobacco products, includes e-cigarettes, or any type of nicotine delivery device, anabolic steroids, sports betting, casino gambling, firearm, or what is deemed adult entertainment in the local government code. The duration of an NIL contract in Texas cannot exceed beyond the college athlete's participation in the actual intercollegiate athletic program. So if say an agent wanted to sign someone beyond their college career, that would prohibit that in that agreement. Pay for play, again, whether or not they're a direct employee of the school. The Texas law is very explicit in stating you are not considered an employee of the institution based on your participation in any intercollegiate athletic program. It specifically addresses autographs. Texas athletes may earn compensation for selling the college athlete's autograph, and also conflict and disclosure. So if the school identifies a provision that is in conflict with the team contract or the institution's contract, or a policy of the athletic department, or a provision of the honor code, which is now something to be aware of, then the school discloses the conflict to the athlete, and the athlete has no more than 10 days to resolve that conflict after the date of that disclosure. Financial literacy and life skills, Texas will require that is a part of the college athlete NIL program. So a workshop at the beginning of the first and third academic years at the school, and it must be at least 5 hours in duration. Of course, include information on financial aid, debt management, time management, budgeting, academic resources. So this is where we really get into the educational aspect of this, which is one of the very good practical sides of the NIL world. Is we're going to be learning a lot more about how to adult here and learn what it means to actually earn compensation, and that you have to pay taxes on it. That's a requirement as well. It's important to remember that all NIL income is indeed taxable income. So Texas law also addresses what are called inducements, and inducements in essence are things to try and attract or recruit to either attend or even stay at a school. The NCAA has rules that prohibit what are called inducements. The Texas law basically states that no individual or corporate entity or any organization who's involved in NIL may enter into any agreement with a student athlete prior to their enrollment at the institution. So they're addressing now, of course, recruits in high school, call it high school athletes. They also may not use inducements of future NIL compensation arrangement for student athletes. The one interesting thing that happened with the Texas law at the final hour, as we were leading up to that all-important July 1st date, was that they originally were going to take effect September 1st. And then when they voted on it, if they had gotten 2/3 of the vote, it was going to take effect July 1st. It was a popular law in the legislature, so it took the July 1st effective date. So it joined sort of what has become part of the new recruiting coin in college athletics, which is NIL rights. Of course, the ironic thing that we know now is that the NCAA didn't really pass the rules that they had been proposing previously. So now the ironic thing is that the states that don't have the laws perhaps could have more freedom in developing their own policy. So all the states that were rushing to pass these laws may have actually passed something more restrictive than what a school would do under the very slim current NCAA policy. And that current NCAA policy provides that it's basically about 4 bullet points that individuals can engage in NIL activities consistent with the law of the state where the school is located. That college athletes attending a school in a state without an NIL law can engage in this activity without violating NCAA rules. That an individual can use the professional services provider, an agent, and that the college athlete, what they refer to as a student athlete, should report NIL activities consistent with the state law or the school and conference requirements, and report that to the school. So essentially, the NCAA not only has taken the hands-off approach, but they're basically leaving all of that, the tracking of the agreements, the disclosure, up to the individual schools, which is certainly a lot for the member schools to be taking on. I think their compliance directors are extremely busy these days trying to figure out, what's going on here in this new Wild West world of NIL. So keep in mind, it's important that, all the other NCAA rules, their bylaws are also still in effect. So the rules that apply to inducements to attend, recruit, or stay at a school are still in effect, or things that may be seen as an impermissible benefit to an athlete, things such as direct pay or benefits outside what's allowable by the current NCAA rules are still impermissible. So as you can see, education is really important here. So it's important to, one, make sure you know what your state law says. Of course, if you're in in a state with a law. And two, what are the relevant NCAA rules? And just know the NCAA rulebook is about the width of a tax code. So it's a very big rule book. It doesn't mean you need to know what the entire rule book is. That's certainly not the high school or college athlete's job. But most of those rules apply to the school and the coach, so they may pertain to how the institutions conduct their programs. But in this new space, it's important for the athlete to educate themselves more about the areas that do apply to this area. So I encourage you to learn as much as you can about it. Certainly, if you wish to engage in NIL at either the high school or the college level. And segueing into that, at the high school level, it's important to know what the high school athletic rules, because that's going to be the governing body for you. What do those rules state? And right now, it appears this is being looked at closely now that we're addressing at the collegiate level, that there's only a few schools that are confirmed where high school athletes are clear to benefit from their NIL. And those states are California, North Dakota, and Illinois. So right now it's only a handful. Those are the confirmed ones, and there's a few others that are being closely tracked to understand whether or not those associations will indeed allow that. Texas is currently prohibited. That has been confirmed. And there are also several states that are now high school athletic associations now considering amending their NIL rules as well. So that's sort of a moving target, much like the state laws have been with colleges for the last 2 years. So who knows? It might change in Texas.
Julie, quick
Yes.
quick question. So I know there's a question in the chat. Will athletes be capped on what they're able to earn? That's the first question. And then going back to what you just said, in terms of NIL at the high school level or moving into the college space. So if I'm a Texas resident, I'm in a deal, like some sort of agreement in a state, it doesn't matter what state I'm in, going to college at?
Yeah, so if you're just looking, so in terms of NIL earnings during high school, right?
Okay.
That's what those high school associations. So of course, much like the recent example of Quinn Ewers, right?
Mm-hmm.
Texas,
Mm-hmm.
to Ohio State, because Ohio, of course, has an NIL law, but it didn't matter anyway, because all the colleges were bound to allow it. So yes, so it's, it's where you are in that moment. And of course, you won't be able to earn collegiate nil until you're in college, which is, of course, what prompted Quinn to leave school a year earlier. So yes, that's an important thing to distinguish there.
And then the question is, will athletes be capped on what they're able to earn?
At the moment, they are not. And there's been discussion that may be considered at the federal level. Not something I would advocate for, but there's a lot of controversy about salaries and compensation. Of course, when you look at coaching salaries, it seems a little bit hypocritical to be thinking about capping college athletes when you've got some coaches making in the range of about 10 million, right? And those are paid by the institution. So, those are backed by Pell Grants and tax dollars and all sorts of things and nonprofit institutions. So to cap third-party private agreements with athletes seems like an interesting prospect. So I think, so it's been discussed, and it's at this point I would call it just a rumor. We haven't seen it in a federal bill that has been dropped yet, and that's still very much something that's in motion at the federal level. So that's the next step after we have this patchwork state system, and this is often the case when you have a clear need for a federal policy. Once a lot of states start passing a law, it happens a lot in consumer protection, then the federal government takes notice. And of course, college sports is very popular. Sports is very popular in our country, which is a great thing. The federal government took notice and said, you know what, we are going to need some sort of level playing field, and we're going to need a federal policy on this. So we've already seen about 5 bills, let me see here. 6 different federal bills have been introduced between the last congressional session, the 116th Congress, and the current Congress, the 117th Congress. Those all vary greatly too. They do not propose a cap yet. And so far it's only been a rumor that it would be capped for college athletes. So we'll see what comes of that. That doesn't seem like that would be an extremely popular position to take, especially after the Supreme Court case this year, where the court very much said, the caps on educationally related benefits, and all the antitrust implications that the court mentioned in their, both the majority decision and then, of course, Justice Kavanaugh's consenting decision were a really big sort of clue as to where, the current environment is in terms of any type of market restraint, which it's going to be interesting to see. and there's a lot of advocacy at that level. If anyone wants to get involved with that, happy to discuss that with you as well after. And I'll make sure that y'all have my email and Twitter, so you can direct message me anytime. But right now, no caps. And I'm hoping not. So let me see here. You want me to pick
There's
up?
another question with will the method taxing of NIL earnings mirror professional sports?
Yeah, so I wouldn't necessarily compare it to professional, but I would say, yes, you would need to, wherever the income is earned, it's going to be subject to the state, whatever state taxes, if there's an income tax in that state. I live in a state where there isn't, in Washington state. So it'd be subject to both federal and state tax rules, depending on where those earnings are made. I see that I need a raise there. So you could move to Washington. We have no income tax here. For those not in Texas or looking outside of Texas, just know that some state NIL bills are more restrictive than others, and it can be a little bit nuanced. Most common state provisions sort of mirror the NCAA policy, which are that NIL rights can't be restricted by institutions. In other words, schools. College athletes can obtain professional representation, and a college athlete's contract terms may not conflict with the institution's contract terms or the team rules. That's in almost every state, though. And then also, an institution may not provide a prospective or current college athlete any NIL compensation. Again, that's also what they're getting at there are the inducements, which means if you come here, you can have this. That's known as an inducement. And this area, what's interesting about this and the way, oftentimes you'll have a law, right, state or federal, and then you'll have how is it actually implemented, how is it being practiced, the reality of it. So what's interesting so far is, of course, the NCAA is responsible for enforcement and compliance, but we're only 3 months into it, and what could be seen as an inducement seems to be a little gray at the moment. And that is mostly playing out in terms of group licensing agreements being developed. For example, if there's a team-wide deal where a member is to earn up to $500 per month, is that seen as an inducement, right? Because they know, well, if I go there and I'm a member of that team, I can earn up to $500 a month. Or covering tuition for walk-ons as an inducement, or even an impermissible benefit under the current NCAA rules. I'll go into one particular deal here at BYU, which sort of raises all of these questions in one. Does it exceed the number of scholarships set for a particular team by the NCAA? Every team in college has of course, a cap on the number of scholarships, depending on whether it's a head count or an equivalency scholarship. And are certain deals that are being executed now, possibly violate that. And just remember, the NCAA is made of the member schools. It is its own entity, but essentially the NCAA are the schools. It's made up of all the member schools of the NCAA. There have been some other interesting questions aside from the inducements in the first 3 months of what everyone's calling this chaotic world. And on its surface, it seems to be playing out well. It's great new economic freedom that we at the Drake Group and myself very much advocated for, the NIL rights of athletes. But if you pull the curtain back a little bit, that's where we're seeing some of the chaos, right? And some of the specific agreements, and the fact that we really have no agency oversight right now. The federal government, as Luke mentioned, in some of the bills, they're proposing that the Federal Trade Commission, the FTC, oversee it. The NCAA had a third-party administrator proposal going for the last at least year and a half. And then at the last minute, they pulled that proposal. So right now, we don't really have a specific tribunal or administrator overseeing and tracking the agreements. Basically, that's completely left up to the individual schools right now, which is a very big burden, as well as it could also raise possible liability questions as well. There are as we just mentioned with the some of the licensing agreements, are some of these invitations for workarounds for rules that prohibit pay for play, i.e. are direct pay from the school to the athlete. Is promotion and publicity, which is obviously a huge part of NIL rights on behalf of the school. Are they creating team or athlete favoritism? Is one team promoted, much more, naturally with the history of it, right? We have the team discrepancies with football being promoted a certain way, and perhaps a soccer team not promoted, nearly in the same league as the football team, right? And marketing is important. Marketing is the name of the game. If you also have of course, the historical gender disparities, we could spend a couple days talking about, the team disparities, the gender disparities, the racial justice disparities. How does that affect? So all of the historical issues of college athletics in terms of equity, racial justice, and promotion and marketing are obviously going to play out in the name, image, and likeness world now. So the interesting question, and one thing that we're exploring right now in the Drake group, is the intersection of what is the institution's, the school's duty in terms of equitable treatment of the athletes, of whether it's by gender, team, race, and what is the actual marketplace, where they aren't subject to laws like Title IX. The schools definitely have to comply with Title IX. I'll just point out that it's been demonstrated, Title IX has taken a beating. I would say it's evolved, but in the 90s, the big thing was, women were getting blamed for certain sports being dropped. Finally, people have come around and learned, oh, no, it's the way the schools are allocating the money. Like if they're allocating all this towards one sport, i.e. football, then they're not equitably allocating that money to women's sports and men's non-revenue sports. So it hurts. It's been demonstrated to also in court cases to actually hurt disproportionately sports and track and field, even soccer, other non-revenue sports. So it has an impact beyond gender. It also has an impact on race, where football will continue to be exploited for the institution to make more money. But then these other unfortunate opportunities get dropped, right? And those sports suffer. Track and field suffers. Soccer, swimming and diving. So it has absolutely both gender and race implications in terms of equitable treatment. That's going to be something to keep an interesting eye on, is what's the institution's obligation in terms of promotion and marketing under the law, and how does that play out in the marketplace? And the other interesting thing to think about that is the history of the NCAA, and even in it was called the Kaplan Report, if people followed that closely, and what happened this year at the Final Four tournament was a lot of those inequities were exposed. If you remember the Sedona Prince TikTok, right? Mm-hmm. TikTok might end up saving the world. So she exposed that inequity in TikTok, and lo and behold, it eventually led to an outside review and report of the NCAA by a law firm. And they found that indeed there's a long history of undervaluing and devaluing women's athletics. And even what's worth taking a look at is the fact that the revenue is allocated inequitably. So the same products being advertised in women's games, which are also selling out, that income is being attributed to the men. So there's a whole lot that really needs to be reviewed and addressed in college sports, even beyond just basic NIL rights, because this will very much affect NIL rights. And that's something that we're talking a lot about in the Drake group right now, which is pretty fascinating stuff. So we're hoping that we don't stop at NIL rights, and we hope that a federal law, of course, is needed for NIL, but we hope that other things are also addressed, and perhaps even a commission appointed where these issues can be studied, at least a 2-year commission, and hopefully, a lot of things can eventually that aren't right can be righted within intercollegiate athletics. And those things can also include medical coverage, equitable treatment, academic standards, which are essentially athletes' rights as well. So,
Julie, we have a couple questions.
yeah, go ahead.
So why did it take so long for this NIL to pass?
Mm-hmm. Well, what's interesting about this is I would say it's taken a long time, but it's been a long time coming too, because we had some really important court cases that were not Supreme Court cases, but they were federal court cases. And those go back to the O'Bannon case in 2009 and also the Jeremy Bloom case. So this is, the sort of the early aughts where these issues really started to come up in court. And I would say that the court cases were really what pushed us to this point. And the NCAA really fought spending a lot of money these court cases. And ultimately, a couple decades later, it hasn't worked out in their favor. So it's unfortunate that all that funding was spent in court, but this is where we are. If you followed some of what the O'Bannon case, that was the video game where they used his and other athletes' name, image, and likeness, where the schools were profiting and the athletes were not at all. So it was those cases, as well as cases like Jeremy Bloom, that pushed this to see. That was decided in 2014, I believe. And then it was 2019 when Gavin Newsom signed the first bill. So it's been sort of an incremental thing that's been building over essentially a couple decades that got us to this point. And of course, once Governor Newsom signed that bill, then that's just the shot across the bow. They were prudent and said, we're going to give you a few years. And then Florida took the ball and ran with it and said, we're not going to give you a few years. We're starting July 1st. And then, of course, now we've got 20 other states who went July 1st. So, or September. So here we are. I'd say it played out over probably about a 15-year period from when those big court cases were first filed. So it took a while, and I think it might take a little longer than we like to have a federal law. We'd like to see one by the end of the year, but with all that's on Congress's plate right now, and the fact that this can be a little bit controversial, and every state seems to have an interest, a keen interest in college athletics, that it might take a little bit of time for a good federal law to pass. So exactly, politics change take time. So, but we're clearly in that zeitgeist moment where it's NIL rates have happened already. It's not going to happen. It's happened. I'll get to the NLRB announcement in a moment, but that's where we talk about things like collective bargaining. Is that going to be a reality? Is actual direct compensation, i.e., pay for play, will that become a reality? And that's going to have a lot of, implications that are definitely of concern to sports across the board. So trying to follow some of the other questions here. Are you seeing some that I'm not?
There's one. Yes, there's one. What happens if an institution or student athlete breaks their contract? Is this contract just voided, or what are some of those repercussions?
Contracts are governed by the terms of what's in the contract itself, and by state law. Contract law is state law, and especially right now, since we don't have an NIL law, it's very much state by state. So it will be dictated by what are the actual terms in the contract, and also state law that will apply. So it depends is the answer there. But there definitely breach of contract is a basic term of every contract. So you have basically offer, acceptance, consideration, which is what you get for performing services or the product, and breach of contract is one of those basic terms. So that will definitely be a part of every contract. And of course, that's negotiable.
So one more. Is there one of the earlier questions was, is lacrosse, would that be considered an equivalency sport or equivalency scholarship, or is that How does that?
I want to say lacrosse is an equivalency. I don't know that for sure. Football is a head count sport. Swimming is an equivalency sport. I'd have to look that up, but for some reason my gut tells me it might be an equivalency sport unless anyone knows.
Tennis? Do you know about tennis?
It's a good question too. There are smaller teams. I'm not sure if that's a head count, or I don't know all the head count versus equivalency off the top of my head. You should learn that.
There was another question, Julie. What were some of the political strategies used for this change for NIL?
I would say the political strategies sort of played out themselves. I would say a lot of it was driven by the court cases that changed that, public discussion of the issues. And I would say a lot of, I wrote an op-ed earlier this year for the Seattle Times that was published in June, and it was about NIL rights, and it was advocating for, of course, NIL rights. And it was interesting to see a lot of people commenting on that. It's still very much sort of a controversial topic for a lot of people. I think it's a lot of people that don't really understand a lot of college athletics and what is demanded of college athletes, and how it just doesn't make sense that they didn't have the same basic fundamental rights that other college students had on campus, especially for how much they work and sacrifice and balance with school. So it's a good deal of writing and contacting legislators at both the state and federal level, and becoming involved with groups like Behind the Whistle and the Drake Group, and making sure that those issues are amplified in those similar ways. Right? We write a lot of position papers. We write a lot of press releases and opinion pieces, and those things help move the needle for sure.
There is a question about if athletes get paid, or as they're getting paid, will this increase college fees?
That's a really good question. That's a very controversial topic too. Should college fee, student fees, which we know are, as I'm sure you know, the person asking that is asked to that student fees go towards athletics, and it's a controversial thing. Is that something that should change? Should fees like that be going towards the athletic department and some of the lavish facilities provided there, the coaching salaries and so on? That's yet to be known. I think if you're saying pay, if it's NIL we're talking about, I would say I don't see how it would affect college fees. But if it becomes pay for play, perhaps.
I'm looking to see if we missed any.
Yeah.
Will college athletes be allowed to join a trading association to help them negotiate deals?
That's an interesting thing, and I'll just jump down to what happened today that's relevant to the earlier NLRB question, and that is the right to unionize or develop a trade association related to NIL and or protecting athletes' rights. So there have been efforts to designate athletes as employees. It's definitely a can of worms. And in terms of that, the right to collectively bargain. Does that mean pay for play, which can be controversial? Or is that extend as far as issues like health, safety, well-being, NIL rights, and academic issues? So what was issued today, September 29th, is a memo by the National Labor Relations Board, the General Counsel, basically asserting that certain, and it's interesting because I think there's more questions raised by this as well. It said certain college and university athletes are employees and should have the right to unionize, among other protections. stated that players at academic institutions perform services for the institution in return for compensation and are subject to their control. So it's going to be interesting. The Abruzzo, the general counsel, also stated that they fully support the conclusion that certain players at academic institutions are statutory employees who have the right to act collectively to improve their terms and conditions of employment. And of course, that echoes what we heard in the Alston case this year, especially with Justice Kavanaugh's separate opinion. It's of course important to note no one else joined that opinion. That was Justice Kavanaugh on his own. So if you read any of the tea leaves there, no one else signed on to that opinion with him. But he stated he very much went after the NCAA and their restraint on college athletes. And they basically added that college athletes have engaged in collective action at unprecedented levels, and that the NCAA shouldn't be restricting that in any way. So it definitely echoes Justice Kavanaugh's suggestions in his opinion. And we're definitely in for an interesting next couple of years as this name, image, and likeness continues to evolve at the federal level. And will it include the right to collectively bargain? What does that mean? What does that mean on a sport by sport basis? And does that mean some type of pay for play? As a lawyer, one thing I think of, and you don't hear a lot in this debate, that's an interesting thing to consider, and a very real reality is if we start looking at employment law in terms of college athletes, is there's a federal floor set in employment law, but much of employment law is also set by the states, and that varies a great deal. So California has some very high standard of protections for employees, and it might not be the case in other states. So how will that play out? Are we looking at another patchwork system, or will it be college athletics that actually helps push employment law to change? We don't know. It's going to be another interesting chaotic discussion as to how will this actually play out. So yes, I wanted to touch upon the NLRB, and if you've watched some of the deals, one thing I wanted to say, because our time is going by quickly here, is in looking at these opportunities, we're seeing certain types of endeavors that college athletes are pursuing when it comes to NIL income. Of course, we're only 3 months into it, but there's all different types. Some of them we only read about, and we won't read about things like college athletes teaching lessons, right? Hosting a clinic, connecting with their communities, connecting with people, which is such a great thing. It's such a great opportunity that athletes haven't had in the past. And it's such a great, not only benefit to them, that they have the financial ability to do that and the freedom to do that, but that the communities that they serve also can actually benefit from the talents of that college athlete. What we're seeing most now in the news stories are, the really big deals, right? They're promoting the products, developing a personal brand, social media presence. It's all going to be important in brand development for sure, but that's definitely just a part of it. Among those agreements, we're seeing things like selling autograph, developing, modeling athletic, non-athletic apparel, promoting all sorts of products and services, of course, within the rules, and making personal appearances. One interesting development are people becoming brand ambassadors. One thing to note is there's been some other really unique, really cool deals that I've seen. So if you're a talented musician or a talented artist, you can now perform, right? Where you weren't able to do that before. The NCAA rules would have prohibited that. So if you have other areas of your life that you now have the ability to promote, if you have other talents, college athletes, we're not all just myopic view of just two-dimensional people, athletics and school, that's it. Some of us have other talents. I played the piano until I was about 8 years old, but I'm sure other people actually have some legitimate talents beyond the athletic field or the pool or the pitch. So you now have the freedom to pursue that. There's a swimmer that committed to Texas who was in the Olympics in Tokyo, incredibly talented woman, who is an incredibly talented bass player from Alaska. So now she's going to have the ability to do that in a fantastic city like Austin, Texas. So, good choice for her. So great town to be in for those types of, other talents and interests in your life. So, don't focus on just the big headlines. We know that only about 2% go pro, which is another reason why, this freedom is important at the college level. But I would encourage, if I were to give some advice, that focus on beyond the short-term goals of NIL. Keep in mind that NIL is a wonderful thing. Make sure you're educated about it, associate with the right organizations and the right people. But keep in mind, this is short-term gain. This is short-term personal gain. And what you have in front of you are careers and lives. And I've seen athletes raising money for charitable causes, using their talents for the greater good. And what an incredible way to position yourself as you move on in the world. I mean, that is fantastic. That's impressive. So keep in mind that, the world's your oyster. You can, be creative in endeavors that you'd like to do. Be mindful of your time, of course. What's sort of the earnings are demonstrating so far is that the average agreement is about $450. So, as we know, even a small amount can go far for a college student, but make sure you make that balance of time, realizing these are short-term games, making, weigh any heavy time commitment, and just make sure that these are legitimate, compliant opportunities. And just make sure to economize your time, because this is a whole new world, and it's exciting.
There are two questions, Julie. One is it that college athletes now have the ability to promote their own talents, or that they can now promote themselves as student athletes?
Both. I would sort of what I touched upon. If you have talents outside of, I guess it doesn't have to be that you're a student athlete. That's sort of a benefit, right? So if you have a talented musician who, can go on Austin City Limits, you can do that. And the NCAA rules previously would have prohibited that as a college athlete. So, that's purely your talent as a musician or an artist of any kind. And then of course, NIL is very much germane to being an athlete, right? That's primarily, that's for all of you, right? So absolutely, it has a lot to do with being a student athlete.
There was one more about, two more really. I think they're kind of related. So if the athletes get paid, what would the role of scholarship serve? And I think in the similar vein, do you think the amount of scholarships will change and more money will be used to give to certain athletes?
Interesting, because that is a provision in some of the federal laws that I've seen and state, is that any NIL compensation that an athlete receives cannot be considered as part of a scholarship offer. So a coach can't make a determination of, well, you're going to get this at NIL money, so you only need this as a scholarship. I'm going to use, the rest of my funds on someone else. You can't do that. So NIL is completely separate from scholarships, and it is it's not allowed to be any type of determining factor as to the amount of scholarship. So that shouldn't change.
So that, yeah, because that would then fall into the inducement category then.
Right. Right.
You're at a big institution. Obviously, there's a bigger market for that. The inducement is implied, I guess, almost, depending on where your institution is, right?
That's right. The field is only so level, right?
Right. Yeah, I mean, because as you know, there's levels to the game, so to speak. You know, if you're a soccer player and you go to North Carolina versus a male soccer player at that's a club sport in Texas, those are two different things.
Right.
You know?
That's right.
Yeah, that's. I think this is going to be an interesting way that the Wild Wild West gets sorted out. This is kind of like football recruiting back in the '80s right now. So we'll see how that goes in the big oil states.
Right. That's right. Yeah, Texas was one of them that saw it and went ahead and passed that law. So it's going to be interesting to see how the federal effort continues to evolve and in which bills will come together as some of the front runner bills.
Right.
And will they address more than name, image, and likeness is a big question.
Right. Yeah, because those discrepancies, like you alluded to earlier, especially with the gender, the racial, and those lines, things that still hot button issues that nobody really wants to touch.
That's right. Medical coverage, academic standards, all really important stuff. And Congress does not act very often when it comes to college athletes. So, we're hoping that this opportunity isn't missed.
Right. Absolutely. Well, that was. We could talk about this all year long if you like. I'd love to know a whole lot more, but I know you have things to do out there in Washington. And if there's anybody has any more questions, Dr. Ingram, did you have another one? I saw you were coming. Did she leave? I think she left. I know Dr. Ingram had another one, but I think she had to go. But is there anyone else that has a question for Ms. Sommer before she exits? I know P-Row, I'm about to beat P-Row up in sixth period tomorrow for his horns down comment.
I saw that. I would say keep an eye as to what's happening at the federal level, and specifically the Commerce Committee in both the House and the Senate. It has a different name in each chamber, but the Commerce Committee in the Senate is one that has been closely involved, and there's been a couple of bills, one from actually my senator who's chair of the Commerce Committee right now, which is a very important position, Maria Cantwell. And so she's chair of that committee. They've held 2 hearings so far this summer. I think there was sort of a crescendo, right, leading up to July 1st and what's going to happen. And then they just let the states, do what they were doing, and now sort of, reconvening as to, what sort of federal legislation will come out of this. It's a guess as to when it's actually going to happen. I mean, I think it's absolutely has to happen and will happen, but will it be this year? Seems to be doubtful. Will it be next year? Who knows?
Right. Yeah, I'm interested because I want to see how that impacts the private schools at the interscholastic level. As you see, there's I know several of my awesome young men at Central Catholic around here, and they're all student athletes. We have a lot of soccer players on here today, and our lacrosse representative. And so the questions that they'll have going forward, I know just being able to access the information and have these conversations is vital. Because after that season ends, I'm wondering, does that gray area of time, how does that impact their ability to maximize their name, image, and likeness?
That's right. That's right. And then perhaps look to possibly the high school association in Texas to eventually evolve.
Right. Yeah. Because they're in a different system. As a private school, they have different rules, and there's no current governance on the private school situation. So this might be the time.
And that public-private is also an issue at the collegiate level in terms of athlete compensation. If we're looking at employer-employee, so it's all complicated thing.
Right. Absolutely.
See, one question here: are you still eligible for financial aid in college if your NIL is collecting income? Again, that depends. That depends on what your NIL income actually is, and that's still going to be, I would say, counted as income. So that could very well affect absolutely what you might be eligible for in terms of financial aid, a Pell Grant, whatever it might be.
And just to piggyback off of that one, that may be something when you're negotiating that deal with whatever organization is, look, I can't officially receive any funds because it will impact my financial aid status. So that's something to consider, but young people have to know what and what does not count towards an asset that has to be counted on their financial aid forms or FAFSA. So that goes back to that financial literacy that's going to be absolutely critical, not only with college athletes, but with high school athletes as well.
Right. That's right.
I'd be trying to get one of those Bobby Bonilla deals if I were a college athlete going forward. I try to get out of 20-year, 25-year deals. It pays a small amount annually.
That's great. That's great. So yeah, keep an eye at the high school level too, because that's changing state by state as well. Some people seem to think that's a controversial thing, but it's something that's happening.
Right. Yeah, I'm figuring since we're out in Texas, we're gonna find a way to get that compensation rolling here pretty soon.
Yeah, it's surprising to see. It's one of the few that's confirmed prohibitive.
Right.
So, yeah, there's about 11 state high school associations in active discussions right now. So, I would encourage people to, explore your advocacy skills too. All of this are really great skills to learn for future careers. It's
Right.
Interesting stuff, interesting topical stuff.
Yeah, absolutely. Just unpacking the rhetoric is probably a great idea. Wish I knew some students that could unpack rhetoric. Let me think. I see a few of them on this call, so that'd be great. But well, Julie, excuse me, we want to thank you for your time. I know you've got a lot to do because we need some of these laws to get passed, please. Help.
Working on it. We want to make sure they're good laws.
Absolutely. So
good laws, just like the good lows.
That's right. That's right. So yeah, if we can help in any way, we're always here. And we thank you so much. That was phenomenal. That was just absolutely phenomenal because last week there was one perspective of the name, image, and likeness, and you gave us the crux of it all, the legal side of it, and the things that we needed to help, the things we need to know. I mean, because our politicians work for us, and we need to make sure that we hold their feet to the fire and make sure that they do their jobs and execute the interest of the people that elected them, or their electorate. And so we appreciate your time and your wisdom and your efforts. So
thank you. Yeah, and I encourage people to get involved with that and keep in mind that we have 3 divisions in college athletics, right? 1, 2, and 3. And all of them are wonderful divisions, and not every college athlete is going to be, making NIL income. So it's important for our Congress to address these other issues as well for the long-term health of college athletics.
Absolutely. I need to get my shoulders taken care of too. They didn't put that in an O'Bannon deal. But no, so thank you very much. Lizette, you gonna close this out?
Yes, just thank you all for being here again. Julie, phenomenal job. We are gonna have part 2 of the series in the spring after some things have taken place, I'm sure, over the next couple of months, especially now that basketball season is right around the corner and some of these other sports are gonna be wrapping up. But we want to say thank you, and we encourage everyone to attend next week. It will be the last part of our series as we end with Dr. Gill, and he's going to talk about some of the social and psychological impacts that these NIL deals have, not only on student athletes, but on the family dynamic, on everyone that's involved in this process. So it's going to be a really, really good conversation. So we encourage everyone to attend. We will put this information up on the website, on our Behind the Whistle website, for you all to see. This this is information and knowledge that everyone needs. And I know that Julie said it already. This is getting you as high school students specifically prepared for some advocacy work that we don't necessarily learn about until later on in college or as an adult. So you're getting a head start to some advocacy work right now, and Julie will with open arms will welcome you to help in this fight, the different fights that that the Drake group is involved with right now. And with that said, we've got all the videos that were provided by the Drake group, so you can kind of get an idea of what they do. But if you need more information, Julie, if you would drop in the chat your contact information, and we're also going to put that on the website as well for you all to have. Thank you for being here. We'll see you next time.
Yes, absolutely. And I'll share feel free to drop me a direct message on Twitter anytime as well.